participation.
Good morning, everyone. Welcome to the weekly Saturday knowledge sharing webinar organized by Mehta and Mehta. And today's topic is bonus shares. And our presenter is Ms. Jaswin Binda, the partner Mehta and Mehta. She handles our Bangalore office. She is at Bangalore. Thanks, Jaswin. Now, today's our Jaswin is a member of ICSI and she is All India rank 9 in her CS executive and is with a different experience in corporate restructuring, IBC, FEMA, DD, many other field, and written various articles on the various topics and speaker at various platforms. Thanks, Jaswin. She is today's presenter, and today's our panelist is everyone knows Tirupal, whosoever is CS, but still I have to formally introduce him. Mr. Tirupal is Gauri. Oh, good. In Hindi, you have written Gaurige. Tirupal Gaurige. He is a partner with Tirupal Gaurige Associates LLP and CS Farm, Bangalore. He is also from Bangalore. And he deals with various corporate law practice. He is a BCom and also fellow member of ICSI. He was qualified in 2001 and till 2004 he was employed with various companies, and from 2004 he is into practice in the various field of company law, management, taxation, finance, corporate legal service. He is also IP and he is handling various matters. He represents before various authorities like NCLT, RD, ROC, OL, his various speakers at the various forum like CA, ICI, ICSI, IOD, and various forums. He has written various articles. He was a key pioneer source for the book of which is published by our CS Institute, ICSI Premium on Company Law, Volume 1 and 2. And also he was also the one of the research member of the Company Law Research Committee constituted by CCGRT. So welcome, Tirupal. Thanks a lot for your time. You are there and it is...
Thank you, madam. Thank you very much. Thank you to all.
Yeah. As usual, we have with us Sudhakar and Mr. Bala. As we discussed or decided earlier, we will not introduce. Everyone knows them. So with that, we should start today's topic. Friends, today's topic is bonus shares. And it's bonus is a bonus, as we say always, everything we would use bonus, freebie. And we say, if I get this, if 60 plus, then people say then extra age is a bonus share. So bonus is usually word freebie. So freebie, and everyone likes freebie. So bonus shares and so the equity shareholders. And the moment bonus shares, everyone would like to appreciate the company. That company is issuing bonus shares. Though nowadays in listed company, very few companies issue bonus shares. Earlier the days when it was regular. And it was very regular in Colgate-Palmolive in earlier days. And people has earned a lot of shares because of that. But these bonus shares are critically used nowadays by the companies for structuring, which we will discuss that how bonus share can be structured for the valuation, capitalization, proper profit structuring of balance sheet structuring, profit utilization, reserve utilization, valuation of shares, and holding the company value, and how this bonus can be critical for that structuring. So relevant provision we'll discuss, and we have all experienced personality with our panel. So with that, I'll request Tirupal to say a few words on the topic, and then Sudhakar and Mr. Bala, and we will start by 11:50. Thanks.
Yeah, thank you very much, Madam, for providing an opportunity to interact and learn from this particular esteemed group and also the participants. Yeah, I think you already explained about the bonus issue. It is a freebie. In India, everything is a freebie. So in the corporate world, it is also freebies. People think it is a freebie. It is nothing but like you have a cake earlier divided into 10 pieces. Now you have a cake. We are dividing into 100 pieces. So there is nothing wrong, nothing, more that you will get. So if you look at the 1 kilo cake, it is a remains 1 kilo cake only. So earlier, what was given was like a something 10 rupees value, and today you got 1 rupee. That means that your own 10 rupee was divided into 10 rupees. 10 rupees are divided and given to you. Suppose you go to the shop and you want to change, then you give the 10 rupees and they will give the 10 chikkas.
Instead of having a
Then do
whole
you
piece,
think,
instead of having a whole piece, you cut
yeah,
and ready to eat. Take it.
that's all. See, the value addition is nothing in it technically. Since you have a lot of, so you will tempt to trade it. Now, earlier you were having only 10 rupee coin, and now you got 1 rupee. So you want to trade, try it, like, okay, let me throw this, okay, in the game. Like, if you go to the any pair, no, any other social events, there will be something, that fellow will give chikkas, 10 chikkas. Okay, take this and you throw it out. So you like a gambling. So you get more number of shares and you will try to do, explore, making some profits. Due to that, there is a possibility of artificial demand of shares and artificial demand for the buying, selling, it may be. And then especially for the companies having huge market value and having the 10 rupees values around like 10,000, 20,000, placing the order for 10,000, it will be difficult. But today you have been divided into pieces. So instead of 10,000, it will become 1,000 rupees. So now everyone is interested to buy some shares of some blue chip companies and all. So the bonus is like a making availability of more number of shares in the hands of the people, like placing them instead of 10 rupees one note and 10 rupee coins in their place. This is my opening remarks about bonus issue. Then we'll listen to the other experts. Thank you.
Rightly put, Sirapal. Real life also, nothing is free in this world. It is only the how you present it. It is the way it is.
Yeah.
It is in real life also the same situation. Thanks
Correct.
for but nicely putting it before the participants. Yeah, Mr. Sudhakar.
Yeah. Hi, good morning, everyone.
Good morning.
And this, as Deepti has rightly mentioned, and of course, Tipal also concurred with that, the bonus is a freebie. But unlike political parties, if the directors also started declaring freebies, that whatever is happening to the states, the same thing will be happening to the corporates also. So the directors should never get tempted to give freebies, like the politicians. According to me, declaration of a bonus issue is one of the most crucial decisions a board has to take. The shareholders always crave for two things. Number one, dividend. And every year they want increase in the dividend. If you give 10%, they will want 20. If you give 20, they want 40. Something go on like that. There is no what's called as reach for the greed of the people. Same as the case with the shareholders, they are not exception to that. Similarly, they also, when the reserve position of the financial statements are getting bulging, definitely they look for a kind of bonus also. Because shareholders also know that bonus comes out of the free reserves only. But some conservative companies, what they do is they don't declare the bonus and they don't declare the dividend very lavishly. Good companies always adopt a conservative policy for declaration of dividend as well as the bonus also. Because with every bonus issue, what is happening is the capital base of the company is getting widened. Service of the equity is also equally important. So it all depends upon the size of the company. There are a lot of nuances are there which the board has to consider carefully before declaration of a bonus issue. Sometimes it so happens that a company might be having a very small capital base, but the company is doing extremely well. And the existing shareholders, they don't want to sell the shares. So that is what Tirupal has mentioned also is by the availability of the shares in the market are not there. So with that, what happened is the liquidity of the shares is not there. So such companies are not the darling of the markets. So to create that kind of a thing, there are two options are there. One is to go for a stock split. Another one is to go for a bonus. So it is up to the company what exactly they want to do it, because stock split as well as bonus, they have their own advantages, they have their own disadvantages. In case of stock split, the company's capital base is not going to be changed, whereas in case of a bonus, it is going to be changed. So it also have some kind of investor confidence. And when you come with the bonus issue, of course, the net worth may not be changed, but the debt equity ratio gets improved certainly, because the equity is going to be enhanced. So obviously, the debt equity ratio will get improved. As far as the taxation is concerned, not much issue in the hands of the recipient unless until they go for a sale. But the main disadvantages of a bonus issue is the widening the capital base, the cost of service, that is by way of declaration of dividend, is going to be a long-term burden to the company. So the company should be that board should be very confident that they are going to service the kind of capital base what they are going to establish. And that is one thing. That's why. And second thing is what happened the moment you declare a bonus issue, the price of that thing will come to in proportion to the bonus issue declaration, the price will also come down. And at the same point of time, because the shareholders are receiving, if I'm having 100 shares and 1:1 bonus is there, I'm going to get 100 shares. Most of the retail shareholders wants to dispose of the shares also. So with that, it is going to have a double impact as far as the share price is concerned. Number one, capital base has increased. Because of that, price is coming down. The availability of the liquidity in the market is going to be more. So people are selling the shares. So for about a year or so, the market will be quite volatile as far as the share price is concerned. It takes at least 2 to 3 years before it gets stabilized. In fact, if any one of you, the participants attend RIL meetings, year after year, every meeting, the pressure from the shareholders on the chairman and the board is for declaration of bonus issues. People say that we don't want dividend, but you please give us the bonus. The moment you give the bonus, they want for the dividend. But companies, what they have to have is the listed companies, that especially top 1,000 listed companies, they have to have a dividend distribution policy. In that dividend distribution policy, maybe the companies also have the board also considered that about the bonus also, they may give 1 or 2 points about that also. Because the shareholders have to have a fair amount of an idea about the distribution of reserves, monetization of the reserves or capitalization of the reserves. What is the board's mindset? That the investor has to also have to understand. If you see in RIL on an average of 7 to 8 years, once in 7 to 8 years, RIL always comes with a bonus issue. If I'm not wrong, the past track is that 1998, 2009, 2017, 2024. This is how the bonus has been declared by RIL. So like this, there are companies out there, whether it is TCS, whether it is any other companies. There are some companies which year after year they give bonus. So shareholders also have the kind of following up that thing. And obviously, those companies will have a different kind of valuation to that of other companies. So I give a pause here and request Bala to take it forward. Thank you.
Good morning to all of you. I think the earlier panelists have elaborately explained the various bonus issues. But I got to say only one thing. As people said, it is a freebie, etc. Now, what happens if you look at the balance sheet? The balance sheet actually talks about the shareholders' fund. Shareholders' fund, A, it is coming capital, B, it is coming the reserve and surpluses. The reserve and surpluses is nothing but it is a semi-capital actually. It is not sitting in the capital class. In the bonus class, what we are doing, we are passing the accounting entry from taking the surpluses from the general reserve to the paid up capital. That is what it happens actually. In the various companies where I was working, always they used to talk, whenever we talk about the bonus share, the overseas companies, they never prefer to have the bonus share. They ask the next question immediately. We don't see the color of the money. So that is the question. So in fact, in one of the companies, when this was highly discussed, because this company, what they have done, as Sudhakar puts it, the company has been very conservative. Very conservative, very conservative. They've been cautiously declaring only the minimum dividend. They have created enough amount of surpluses actually. At one point of time, the paid up capital versus surplus was something around 10 times more than what they had the paid up capital. So they wanted to issue the bonus share. Totally, the major shareholders who were sitting abroad, they were not interested. They asked the question, where is the color of the money? Ultimately, what we have done, we have actually gone to those days, NCLT was not there, it was the High Court. We formulated in the old 1956 Act, Section 392, 393, 394, compromise and arrangement with the shareholders. We actually refunded the cash to the people at that particular time. That is what we have actually done. Some of the companies also done in the past, actually. That is one issue. Second issue is, as rightly puts it, what happens is the bonus by and large is declared by those companies which are having the share values very high in the market. So that means the tradability is not there. The investors are not able to afford the shares. So by issuing the bonus, what happens? The value come down at least proportionately near total of the 50%. So it enables the new investor to invest the money. That is why, as Tripal explained, the demand is created, the shareholder base get extended, trading things goes on. And as Sudhakar puts it, the next 1 year, the volatility and other thing and all which all happen, that is what the intricacies. But anyway, all said and done, how do you look at it? But there are various intricacies. Because the basic issue is, when you talk about the bonus, you don't have to have the liquidity of the cash. It is just the book entry. So that is not going to be affected. But apart from that, various other issues, intricacies, what are the things you can declare, what are the things you can take into consideration, all those things are all there. It's a very small topic, but it is still, it got various intricacies which we'll go through. I think when it comes to the listed company, there are more procedural issues and other thing, compliances are involved compared to the unlisted companies. So let us go over it. I think we have the expert of Tirupal and Sudhakar who has been well-versed and handling the things and have the practical experience. They will share with the practical. We'll have the benefit of that. One thing is there, nevertheless, the topic is more important. As we can see the participant, it is already more than 200 people. So that itself explains what is the importance of the topic. Over to presentation.
Yeah, Jaswin, go ahead. Start the first.
Thank you so much for the introduction on the topic and a very good morning to all the participants. I'll just be sharing my screen and starting the presentation right away. So in our series of masterclass on issue of securities that has been going on, this topic that we're going to cover today is insight into issue of bonus shares, which has elaborately been taken up by the panelists in the introduction. So answering the first question as to what exactly is bonus, what is bonus issue? So bonus issue is also referred to as capitalization issue, which means the process by which a company issues additional shares to its existing shareholders without making any cash payment. So it is a conversion of free reserves and accumulated profits of the company into the capital. Characteristics of bonus issue: there is no involvement of cash, no impact on the cash flow of the company. It is issued purely out of free reserves of the company, and the bonus issue is proportionate to the existing holding of the shareholders. Practical advantages of bonus issue and how does it impact the company?
Just wait 1 minute. Can you please go to the previous slide?
Yes, sir.
See, in the second bullet, just where you mentioned it is the issue of shares by the company by conversion of its free reserves and accumulated profits. The word conversion is not an appropriate word. We are not converting the free reserves. We are capitalizing the free reserves. Several times it happens that in case of rights issue also, what people do is that suppose if the applicant is having some kind of a loan, he lent some money to the company and he wants that money to be adjusted against the application money for the rights issue. People used to use the word conversion of the loan into a rights issue. The moment you say conversion of a loan to a rights issue, then again the procedural compliances are entirely different. That subsection 3 gets triggered. So wherever you are using this word conversion, you have to be very careful and you have to use appropriate words only. In the resolution, if you use the word conversion of free reserve, that is not correct. We have to use the word capitalization of reserves. Yeah, please go ahead.
Thank you, sir. So the practical advantages of bonus issue, it enables the company to retain the money that is available in the free reserves and surplus. Since due to the capitalization of reserves, it gets converted into the equity share capital or the capital of the company. It helps in reducing the market value of the company's shares. So generally, prior to a public issue, most companies undertake a bonus issue. So as the valuation of the shares become nearer to the nominal value and makes the shares more sellable. For already a company that is already listed, issue of bonus shares due to the market sentiment increases the market price of the company and enables the shareholders to realize profits, of course, subject to lock-in if any applicable. Applicability of provisions. In case of unlisted company, for bonus issue, we will have to look at section 23 and 63 of the Companies Act to be read with Rule 14 of Companies Share Capital and Debenture Rules 2014. As well as the Secretarial Standard 3, which is the Secretarial Standard on dividend, also details and has certain provisions related to bonus issue.
Maybe here you can inform that SS3 is an optional one, not a mandatory, because you are saying applicability of provisions.
Yes. So,
as on
Yes,
date, the secretarial 1 and 2 is actually mandatory, but although Institute has come out about 10, it is preferable people
correct.
adopt all the secretarial standard. This is one such standard. As on date, it is not actually mandated, but people do follow voluntarily. And I think we should follow voluntarily being a company secretary.
Yeah, that's correct. See, what happens, this SS3 provides a lot of practical support to you. If you follow, you will get 100 things to, a lot of question answers will be resolved. That is the reason that they have mentioned here is applicable to help.
Yeah, time again, I have been actually telling in the various forum, Sudhakar is also supporting the secretarial standard, which is issued by the institute. Not only that, along with the guidance note, which is issued in many topics, is really, really helpful, which actually give the various illustration examples, how to tackle the thing. You'll get many answers to that. I think we should actually refer that. As you rightly said, the Secretarial Standard Board has actually put extraordinary efforts. Here, I also would like to appreciate all of you are there in the Secretarial Board at one time or other, continue to be there. You have been doing an excellent job. My hats off to you.
Please proceed.
Yes, thank you. In case of listed company, if we look at applicability of provisions, we have to look at Companies Act 2013 and the rules made thereunder. As well as the SEBI Issue of Capital and Disclosure Requirements Regulation 2018, which is the ICDR regulation, and the SEBI Listing Obligations and Disclosure Requirements Regulation 2015, which is the LODR regulations. So now to understand a little legislative history as to bonus issue, the Companies Act 1956 did not have any special provision related to bonus issue. However, the proviso to Section 205 of Companies Act 1956 mentioned that the company can issue fully paid up bonus shares by capitalization of its profits or reserves. And later on, the ministry had come up with a circular stating that revaluation reserves cannot be utilized for the same. But when the 2013 Act was being framed, they provided a special provision and a special section, which is Section 63 of the Companies Act 2013 as we see it today, which is dedicated completely to bonus issue. Enabling provisions under Companies Act 2013 and the rules made thereunder. So the primary provision under Companies Act related to issue of securities, which is Section 23 of the Companies Act, states that a public company may issue securities to public through prospectus, through private placement, rights issue, or can also issue bonus shares by complying provisions of the Companies Act and the SEBI regulations in case of listed companies. Similarly, it gives the right to the private companies as well to issue right shares, bonus issue, and private placement. Section 63 of Companies Act. Section 63 enables companies to issue fully paid up bonus shares to its members. Further, it also details on the specific sources that can be utilized for issuance of bonus shares, which is free reserves, securities premium account, and capital redemption reserve. Further, they have also stated that no capitalization of reserves created by revaluation of any assets can be utilized or can be capitalized for the bonus issue. So now understanding the definition of free reserves. So free reserves as defined under the Companies Act means reserve which as per the latest audited balance sheets are available for distribution of dividend. However, there are two particular exclusions from this definition. So any amount representing unrealized gains, notional gains, or pursuant to revaluation of assets cannot be treated as free reserves. And any change in carrying amount of any asset or liability that is transferred to reserves cannot be treated as free reserves as per the Act. Coming to the definition and yes, sir. Securities premium account. The Companies Act specifically states that where the company issues shares at premium, whether based on cash or otherwise, the sum equivalent to the aggregate amount of the premium received on such shares shall be transferred to securities premium account. Further, the section states that securities premium account, amongst other kinds of issues, can be applied towards issue of unissued shares of the company as fully paid up bonus shares. So this states that securities premium account can be used for the issue of bonus shares. Capital redemption reserve, section 69 refers to capital redemption reserves, which means where the company purchases its own shares out of free reserves or securities premium, a sum equal to the nominal value of the shares is required to be transferred by the company to capital redemption reserves. And this capital redemption reserve may be utilized in buying unissued shares of the company pursuant to issuance of fully paid up bonus shares. So securities premium can be used for other purposes, including bonus issue, but CRR can be used only for the purpose of bonus issue by the company. Certain conditions as per section 63 for issuance of bonus shares. There has to be a specific authorization in the articles for issue of bonus shares as well as authority to capitalize the free reserves of the company. The board of directors is required to recommend the bonus issue of shares. Bonus issue also requires specific authorization in the general meeting of the company. Further, a company can issue bonus shares only if it has not defaulted in payment of interest or principal in respect of fixed deposit or any of its debt securities. And the company should not have defaulted at any point in time in payment of its statutory dues to employees in respect of PF, gratuity, and bonus. Further, before the bonus issue, the company shall ensure that any outstanding partly paid up shares should be required to be made as fully paid up shares. So, any
Just
inputs
1
on
minute.
this? Yes.
1 minute. Just please go back to the previous slide. See, several several times what happens is several sections of Companies Act says, provided there is an authorization in the articles, any corporate action, that is very, very important. Several times my experience says that with all due regards, company secretaries or directors, they don't go through the articles of association that minutely. And about a couple of months before, one of my friend who is a chartered accountant and he is on the board of a company, there was a proposal for declaration of bonus issue. And when he was becoming a chartered accountant, he sought my guidance on how to conduct and all those things. That point of time, I have mentioned to him, as I always used to say, please be thorough with the articles of association because the board procedures, the director's powers, duties, responsibilities, etc., they are there in the articles. So when this declaration of bonus issue was there, he has gone through the articles, and unfortunately, the articles were not authorizing it, and the company secretary has not noticed that. Obviously, at the board meeting, the director, who is a chartered accountant, he has raised this issue. There is no authorization in the articles. Can the board consider the declaration of a bonus issue? And the chairman was a promoter and he looked towards the company secretary, and the company secretary, obviously, he will get panicked, immediately brought the articles. Unfortunately, see that company secretary was not even having the articles of association in the boardroom. Why I'm saying this thing is not to point out anything, but whenever we go to the boardroom, certain documents we have to carry, which should be handy, like your Companies Act, any security regulations, whatever the relevant papers are there, you have to have it handy. Articles of association was not there. It almost took about 10 to 12 minutes before they lay their hands on the articles and they brought it because that they have to take a printout of that, etc. Anyway, now there is a panic among the board how to go about it. So fortunately, what happened was that this friend of mine, he called me and he said, I'm in a board meeting. This is the issue, how to go about it. I said, you have to amend the articles. You have to amend the articles and then you can bring it. So amendment of articles of association as well as the bonus issue, you can bring it in the same that extraordinary general meeting also. Only thing is the first resolution should be for increase in the authorized capital and also for declaration. Authorized capital is also not there, unfortunately. So they have to increase the authorization of increase the authorized capital first. Before that, they have to amend the articles for the declare. I mean, okay, to give the power to declare the bonus issue. After that, the third resolution is this. Then how to put it before the board? All these things, supplementary agenda items. I asked them to adjourn the board meeting, reconvene that, and then bring this as a supplementary agenda items, and then go ahead. Anyway, that is all procedural matter. One can always handle that. But what I'm trying to say here is the learning out of that is, please, with all due regards, again, I'm submitting to the participants that whenever this kind of corporate action comes, please go through that. First and foremost thing is whether we have that considered, because the company secretary thought it is by default, it would have been there. But you cannot take it for granted. By default, it would have been there is not an answer to that. You see that he has to cut such a sorry face. He was a very efficient company secretary. I know him also very well. He is a very efficient company secretary. But unfortunately, what happened is sometimes maybe with overconfidence or maybe some kind of a negligence, some not because of the diligence, we take the things for granted. Sometimes you may be having your support, your right-hand person, left-hand person, whoever it is at all. But when you are entering into the boardroom, the company secretary cannot take the things for granted. He has to have a backup papers file with him. In that, he should have authorized capital, how much is the paid up capital, what is the possibility for further issue of capital, articles of the authorization, which suppose if a director put which article is authorizing me to declare the bonus issue, he should be able to spell out the article number. And then after that, you have to also say this thing. Then, I mean, all these three things are supposed, for example, God forbids, if any this kind of situation comes, there is absolutely no issue to get panicked. That immediately I mean, give your apology and then remedial measures you have to be quickly come out with that also. You can always amend the authorized capital clause. You can always amend the articles in the same amendment, same meeting. You can also take all these three resolutions also. So I thought I will take this opportunity wherever this kind of some flaws happen, with or without our consciousness and all. This is how it is to be handled. Please go to the boardroom fully equipped with all the things. Thank you.
Yeah, further, I
Tirupal,
think,
would you like to say something
sir,
about it?
yeah.
Yeah.
See, what I would like, I think there is a query, I think Mr. Madhura Gandhi, I think. So question comes, should we need to wait for the approval of the MGT 14 altering your AOA? The answer is no, you don't need to wait, because if you look at the section 14, 14 requires you alteration, and approval of the alteration of AOA requires only the two circumstances. Prior approval is the change of name, or you are converting into the public to private, private to public. Only three circumstances, I think, you may need ROC approval. In all other case, any amendment that you do to your AOA will be effective from the moment you pass the special resolution. That's what the sir is trying to tell you. Moment you pass a special resolution, having a provision, enabling provision like capitalization of profits, insertion in your AOA, that moment you have a power and company can proceed further in approving the bonus issue. If it has a sufficient other share capital, if not there, then you enhance the other share capital. Again, the other share capital also will be effective from that moment on. As per section 61, you don't need the share ROC approval for your increased capital. So increased capital also will come into place that moment itself. Filing forms is just only procedural aspect, but shareholders have increased the capital, shareholders have amended the AOA, and then increased the capital, then shareholders have approved the bonus issue, there ends. The next moment, company even conduct a board meeting and allot the bonus shares. Allot the bonus shares. No approval from the either authority. I'm just giving plainly, but it may be there any other approval like stock exchange, that is different, barring. In general, I'm just telling. So there is no requirement from the ROC angle, especially for MGT 14 approval under. You can file subsequently, there is no barring. And one more thing, what I'm just trying to draw it, sir, as per the table F is concerned now, and there is a specific provision about the capitalization of the profit. Okay, that is the article. Let me open that. I will just show you. It's Article 39. Sorry, that is Regulation 39 of the Table F has the capitalization of profit. Similarly, the Table A of the 1956 also has the provision for capitalization, as I believe. So the only issue that we need to look at, are we adopting the Table F or not? Or are we adopting the Table A or not? If you look at the first maybe few lines of your AOA and MOA would be knowing that whether the content of the table F or the A is applicable to as such, or it is modified in the manner in your AOA. If suppose there is no provision made for the capitalization, then intact, if you have adopted, means table F comes into place as it is, and you can simply refer to your board, sir, we are adopting the partially table F and partially the MOA, AOA, and AOA has specific matters and table F has a general matter. So table F has the specific provision called the regulation 39. So as per that, we are unable to go for the bonus issue. Maybe I'm just giving idea. If it is have a thorough provision, if you got as a thorough AOA, professionally adopted AOA means, then certainly it will help. Even if it is not there, maybe director who has seen that provision, he would have been panicked because of there was no specific provision as mentioned in the section 63 or in the regulation 239. So it is very clear. You can adopt the table F and then your own article. Both can be adopted. So how you have drafted your table and AOA matters. Thank you.
So the essence of what Tirupal has spoken just now and what I spoken a little while before is, as a company secretary, whenever you are entering into the boardroom, or as a practicing company secretary, in case if you are handling the board meetings of your clients, you should be thorough with your articles. Whether you have adopted table F, whether you have adopted table A, whether you have your own articles, and that particular corporate action, whether it is already taken care in the articles or not, that you should be equipped with them. And sometimes it may so happen, some directors may ask you the questions also. What is our authorized capital and what is the paid up capital? Suppose if you don't have that handy with you, you have to cut a sorry face. So please, what has to go with adequate preparation to the boardroom. not only with the Companies Act or the legal provisions. That is not that important. Procedural part is not very important because that comes at a later stage. But the primary part is that these are the 3, 4 things what Jaswin has mentioned in her presentation. That is very important. And second thing is also that several times, with all due regards, again, people just download the resolution of some other companies and adopt the same. And please don't do that also. That is also equally important because your issue, the way you are doing it, it might be slightly different to that of the other persons, what they are doing it. Yes, definitely you can take a guidance from that particular resolutions, but not just the stereotype kind of a thing. Yeah. Yes, that's
Both of you actually well said, actually. One thing I would like to add here for the interest of the profession, whenever the company, the very first thing is he has to thoroughly go through the MOA and the AOA of the company. That is one. Second thing is there, as the regulations are changing every day and the amendments are happening, we'll have to also see whether the MOA and AOA in line with the current requirements or not. In fact, there were old companies, I'm talking about 2 decades ago, when the buyback was not there in the 1956 Act actually. Because the 1956 was there, none of the companies had the buyback option at all. It was amended only later in the year 2003 or something like that. The moment it has come, immediately I got my article, some MOA article amended to include this particular clause. Then after that, people said, the company is going to buyback. I said, buyback or not, I do not know, but the amendment is today, we'll have to bring our AOA and MOA in the line that after that, many people have actually done it. So really speaking, as you rightly said, when you say the preparation, first thing is you have to know your MOA and MOA right from the day you join. You have to bring it to the update to the current regulations, etc. As and when the amendments takes place also, you have to keep, altering the article and memorandum, not wait for till the moment of the action take place. As Sudhakar puts it, what happened, you run into the panic. That situation should be avoided. That is what I would like to add here. And second thing is there, when Sudhakar said it very clearly, you have to go to the board meeting well prepared. Whether it is required or not required, please carry your MOA and AOA with you for every board meeting. Carry your company's act with you every board meeting. Because when some question asks, immediately in handy, you can refer. You cannot say, just give me some time, I'll go and bring the book and other thing and all. That doesn't look nice actually. So these are all the things practically one has to actually follow. I think with their experts and the practical views, it has been well brought out. That is what I also thought of sharing it. Thank you.
Sir,
Go ahead,
one more point I would like to see. Whenever you modify AOA and MOA, like Companies Act, no, it is always better to have a footnote, annotation when it was amended with the date, all those things. That will help. Like you have a Bare Act, all footnotes are there. Someone prepared by like editor of some booklet, you will prepare. So that's what, one should have it. Otherwise, we don't know when it was amended. If there is a question, there's a probability there you will not be able to answer this.
Yeah, you're absolutely correct actually, because we always used to do one thing. And second thing is what we used to do whenever we used to amend the article, what we do is we used to change the color. The moment look at the color, oh, green color, it is the amended article, current one. Blue color, no, it is old. So that is the way we used to work. We used to change the color actually. By looking at the color itself, we know whether it is the current article or whether it is the old article. The always footnote will appear, as you rightly said. That is a very good practice actually. Yeah.
Yeah, practical tip. Yeah, Jaswin, go ahead.
Yes, thank you so much for the practical inputs to all the panelists. Further provisions under Section 63 of the Companies Act, bonus issue cannot be and shall not be issued in lieu of dividend. This is stated under Section 63 as well as the Secretarial Standard 3. Like Trupal sir already highlighted, SS3 is not mandatory right now, but definitely it's a recommended measure, as well as it already finds place in Section 63 as well. Second is
not only that, Jaswin, nowadays many regulators in their ROC orders, they are referring the various secretarial standard. I have recently come across some order where the SS3 has been actually referred in one of the judgment very clearly spelling out the institute has brought out with a guidance note. The company secretaries are actually required to follow this, etc. Very clearly, they are filling out. That much recognition is there today. So, as you rightly said it, yes, it is not only mandatory, but it has to be adopted voluntarily, and we'll have to follow it. Yeah.
Yes, thank you, sir.
Please go ahead.
Rule 14 of Companies Share Capital and Debenture Rules 2014 says that bonus issue cannot be withdrawn once announced by the board. Coming to the provisions under Rule 9A and 9B of Companies Prospectus and Allotment of Securities Rules 2014. So this is only for the purpose of dematerialization of shares as an additional point what we have stated to ensure that we cover the entire process. So Rule 9A covers unlisted public companies except Nidhi Company, government company, and wholly owned subsidiaries. And it states that the company shall issue securities only in dematerialized form. And prior to bonus issue, the company shall ensure holding of promoter, directors, and key managerial personnel in demat form only. Further, any holder who subscribes to bonus shares shall ensure all his securities are in demat form. By a recent amendment, the Companies Act and the lawmakers extended this to the private company except small companies by introducing Rule 9B, which I'm sure everybody is aware about. So this states that the private company shall also ensure issuance of any securities in dematerialized forms. Prior to bonus issue, the holding of promoter, director, and key managerial personnel, even in a private company, shall be in demat form only. And the holders of securities who subscribe to bonus shares shall ensure that their securities are in dematerialized form.
Just 1 minute, just wait, please go to the previous slide.
Yes,
See, in
sir.
this case, in the third bullet of the private company, you have mentioned that holder who subscribes to bonus shares shall ensure his securities are in demat form. In case of a bonus issue, we know that there is no question of subscription. Okay. But whenever a company, whether it is a private company or a public company, listed, unlisted, whatever the company may be, now it is very clear under the Companies Act, the promoters, directors, and KMPs, before the corporate action, they have their shares are to be mandatorily in demat form. That as a company secretary, we have to ensure. After that, it may so happen, all shareholders may not be having their shares in demat form, especially in case of private companies or closely held public companies. Suppose one shareholder, in fact, in one of the cases, what I have been asked to advise is, one shareholder was not traceable, and that company wants to come with a bonus issue. And that shareholder is not belongs to promoter or even director or KMP group. Now, how to go about that? Can the company declare the bonus shares or not? So, company can do it. Only thing is, for that particular shareholder who is not having his shares in a demat mode, you cannot issue the share certificate. What you have to do is you have to keep those shares in a separate escrow account kind of thing, in a demat form only. And as and when that shareholder comes back, you have to ensure that he has opened a demat account, and then these shares can be transferred to that particular demat account of the concerned shareholder. This is what is to be ensured. Yeah. Yeah, just go ahead.
Yeah, see, this may be said, if you look at the rule of the demat, so when they made the demat mandatory for the other than small companies, they have given 18 months time, depending upon that is a financial year. So this 18 months time is not only for the existing companies as on that day, means as on that I think 31st March 2023, 18 months you have been given time, so that it was the 30th September 2024. Now, that because thereafter also is there, the word thereafter is given. That means next, suppose you got created in between a company. In between a company, it will get from the date of incorporation till the date of financial year, first financial year end. Suppose it is a big company, or it is a subsidiary, or it is a holding company. Okay, they have created recently. And till the end of 2025 March. And from there, you will get 18 months time. So this there is no clarity need. So you have got another 18 months time to get your existing shares dematted, and further shares issued after 18 months only mandatorily should be the demat. That was the demat rule. But if you are already into the basket of existing companies as on the date of 31st March 2023, then you have no option. Then you have to ensure that the entire promoter, then thereafter directors, then KMP should be there in demat mode, and the allotment of bonus issue should be done only in demat mode. That is my claim.
Moving on to the procedure for issuance of bonus shares in case of unlisted companies. This is to summarize the entire process in case of unlisted companies as per the Companies Act. So first, the board meeting shall be called for recommending the issue of bonus shares. Further, this shall be under Section 63 as well as read with Section 179, which is issue of rights of powers of the board. Further, upon the conclusion of the board meeting, the company shall be required to file MGT 14 within 30 days. This is applicable only in case of public companies under Section 117 of the Companies Act. Where closure of books is applicable to the company shall be required to issue an advertisement for closure of a register of members at least 7 days prior to the book closure. So in case of public company, this shall be issued in two newspapers. One is the vernacular newspaper of the place where the registered office of the company is situated. And second shall be in an English newspaper having wide circulation in the area where the registered offices of the company is situated. In case of private companies, the advertisement shall be sent to all the members. This is as per Section 91 of the Companies Act. However, there's an exemption in case of closely held company where the list of shareholders and a list of members can be determined conveniently. Such advertisement will not be required. In case the company has a website, then the website disclosure of the book closure is mandatory. The company shall be required to hold general meeting for passing of ordinary resolution under Section 63. Upon the approval by the shareholders, a board meeting shall be conducted for allotment of shares pursuant to Section 39, which deals with allotment, and Section 63. Once the shares are allotted, the company shall update register of members under Section 88 to ensure that the bonus issue forms a part of the register of members and effect is given to the same. Filing of Form PS3 with Registrar of Companies within 30 days from the issuance under Section 39. In case the company has any foreign shareholders, the company shall be required to file the Form FCGPR within 30 days to RBI for the same. And last is the delivery of share certificates in physical or filing of corporate action request with the depositories, which we already saw in Rule 9A and 9B as to the applicability of dematerialization.
Yeah, here I would like to clarify about the Section 91. If you look at the Section 91, it reads like power. That's the power to close the register of members or the debenture holders or other security. So technically, it is a power given to the company, but in the very same section doesn't say what purpose. You have been given a power to close the register, but it doesn't say that following circumstance you are supposed to close and comply the provision. What I'm trying to say, if you look at the section right issue 62(1)(a), it says as on the date of offer who are the equity shareholder. So section itself identifies the day when we are supposed to draw the list of the shareholders who are entitled for the rights issue. In the bonus issue, neither such requirement or neither such mandate is there, nor in the section 91 that the 91 will be triggered when you are going for bonus issue. What I'm trying to say, in case of private limited company or even a public limited company, the list can be drawn. But drawing the list, you don't need to close the register of members. That's what, because the section silent about what purpose you are supposed to, you need to close the register of members or register of share transfer. Nothing is given. And the section 91 is like a process. If you decide, if you want to go, you go this way. Whether should I need to decide is the question. First question we should answer in case of bonus issue. Should I need to close the register of member? Because section 63 doesn't say that. And section 62 in respect of rights issue, section itself identifies saying that as on the date of offer, who are the holders of equity are entitled to get the equity share. So what my submission is there that 91, if you decide to close, then only to appeal. That is my submission.
Yes, thank you, sir. Now moving on to the enabling provisions under SEBI ICDR regulations 2018, which shall be applicable for listed companies. So regulation 293 of the ICDR regulation specifies that listed companies shall be eligible to announce bonus issue. So this covers both announcement as well as issue of bonus shares if it is authorized by the articles for bonus issue as well as capitalization of reserves. If there is no such authorization, the company shall first pass the shareholders resolution for altering the articles. Approval from stock exchanges for listing and trading of all the securities issued prior to the issuance of such bonus shares shall be obtained by the company. Companies should not have defaulted in payment of interest in respect of fixed deposits or debt securities. Companies should not have defaulted in payment of any statutory dues of employees with respect to provident fund, gratuity, and bonus. Any kind of outstanding partly paid up shares as on the date of allotment of bonus shares shall be made fully paid up by the company. And any promoter or director who is not should not be a fugitive economic offender. Coming to section yes, yes, sir.
Just go back to the previous slide.
Yes, sir.
See that Sven has mentioned that whenever you're coming with a bonus issue, that the shares are also to be fully paid up. That means this situation arises when the company has made all, I mean, at the time of allotment of that IPO or rights, whatever you may call it as, the entire money was not asked on the application. There was a call money concept was also there. So that share, if the call money are not paid, then the shares will be partly paid shares. So now, unless until those partly paid shares have been made fully paid up, the company cannot come with a bonus issue. Now, how it can happen? One way of thinking is that the companies, normally it has a provision in the article that the dividend can be adjusted against the call money due from the shareholders. So dividend, in case of any kind of call money is due, the company can also charge some kind of an interest on that, so that the call money as well as the interest can be adjusted against the dividends. But still, if the shares are not fully paid up, and despite the fact it is reminded to the shareholders they are not making it, then the company has to forfeit those shares. And definitely for forfeiture, there should be again an authorization in the articles. So before coming with a bonus issue, the company secretary has to ensure that number one, the shares are fully paid up. And in case the shares are not fully paid up, please do send reminders to the shareholders and giving him sufficient time. At the same thing, you have to also mention that in case the whatever the call money is not paid up by so and so date, with or without interest, whatever the case may be, then that shares will be lead to a forfeiture of shares. Then there is a procedure for forfeiture, very stringent procedure is there that need to be complied with. Then only you can come with a bonus shares, otherwise not. Yeah.
1 minute. That will give answer because there is one question in the chat box that whether partly paid shares can be made fully paid shares with the bonus issue. So you answer that.
Yeah, one I would like to draw the one of the provisions of the table F. If I am allowed to share, no, I can share it.
Yes,
There's
please
some
go ahead.
material.
Please
There
go
is
ahead.
some material that is available. Can you? Yeah. Can you see the material now?
Yeah, we can.
Yeah. So this is the capital. This is the table of regulation 39. The company in general meeting may, upon recommendation of the board, resolve that it is desirable to capitalize any part of the amount for being standing to the credit of any of the reserves or to credit of the profit and loss account otherwise available for distribution, and to such one accordingly set free for distribution. That means should have been distributable profit. Now let us come to the second one. This is the one and second. The sum aforesaid. That means what you have kept ready with the shareholders' approval, aforesaid shall not be paid in cash, but shall be applied subject to the provisions contained in clause 3. There is a clause 3, either in or towards. Now let us look at the A. A says paying upon any amount for the time being unpaid on any shares held by such members respectively. The next proportion, paying up in full unissued shares of the company to be allotted and distributed, credited as a fully paid up to the and among such members in proportionately aforesaid. Then you say partly in any in a way specified in subclass 4A and partly in that specified in subclass B. So I'm just drawing this particular provision. It appears to be before you go with the fully paid bonus issue, you can also apply those funds that is available for the distribution of dividend can be applied, can be given credit as a fully paid money.
This is which one? This 39 you are talking about. This is what articles, rules, regulation.
Table F.
Table F.
Companies Act.
See,
Companies
now
Act Table F.
in this case, Tirupal, what the problem is? Suppose you have 1,000 shareholders. 900 shareholders have paid the call money. 100 shareholders are not paid the call money. Can you adjust like this? You can't.
That's what I'm just giving. Proportionately, they have given word. What is the word proportionately?
See, proportionately means, suppose, for example, see, Companies Act also says that you cannot demarcate the shareholders. Okay?
Correct.
You
Among
have to
them.
treat all the shareholders alike.
Equally.
Now, 100 shareholders are indisciplined and they have not paid the call money, despite the fact the reminders have been sent. And what you will do with them? 900 shareholders have paid the call money within the due date.
Correct.
So you cannot apply this particular provision there. What you have to do is you have to mandatorily go for forfeiture of those 100 people only. Otherwise, the 900 people will say, give us our money back then.
Yeah, this is the one situation, sir. I think you are rightly pointed out. Yes, you have to collect the money and then if not, then forfeit it. What I'm just trying to draw the attention is, suppose there is a call money is due from the company to be called for everyone uniformly. Call money is due. Like suppose out of 4 calls, 3 calls were made and 4th call is yet to be made. Now company has enough money, means enough resources that let us go bonus issue. Now, should I need to make a call, 4th call and then get the money? Then after go for suppose call money, 4th call will be called after 1 year only. That means should I need to postpone my bonus issue after 1 year? So I feel when I'm giving uniform treatment for everyone, that 4th call will be suspended. Now I'm going to give everyone the 4th call, whoever has to pay will be used by using this particular fund. Whether this situation can be used. This is I want to draw the attention. That's all. Nothing else.
according to me, this need to be examined based on this thing. I cannot comment either way. You know.
Sir,
It
okay,
need to be
sir.
examined.
Thank you. Thank you.
Okay.
Yes. Moving on to regulation 294 of the ICDR regulation, which states certain restrictions on the bonus issue and certain procedures that need to be done. So, if the issuer has compulsorily convertible debt securities, then the issuer shall make reservation of equity shares of the same class for holders of outstanding compulsory convertible debt securities in proportion to their convertible part. The equity shares reserved for such holders of fully or partly convertible debt securities shall be issued to the holders of the instruments on the same terms or in the same proportion at which the bonus shares were issued.
Sir, what is the situation for the unlisted company having the convertible instrument? Should we need to look at their terms and conditions alone? Should we need to voluntarily reserve? Is the question.
See, there, you know, you are actually technically speaking, Companies Act and rules are silent about it.
Yes, sir.
Okay. So I'm sure that, you know, okay, if the terms and conditions are barring the convertible security holders from the bonus issue, then it won't be. Otherwise, according to me, you have to give them the way in the ICDR it is mentioned. I'll say one more thing also. So in case of stock options, employee stock options, right? In the employee stock options also, when you pass the resolution, when the scheme is what's called approved by the shareholders, we don't say these things very minutely. In case of bonus issue, this happens. In case of rights issue, this happens, and all those things. We use only one word for any kind of corporate actions. The ESOP adjustments will be appropriately made by the ESOP committee. That power we give it to the ESOP committee. So then ESOP committee will adjust it. Suppose if that bonus issue is coming, then what will happen is, say for example, I'm entitled for say 1,000 bonus shares. Sorry, 1,000 stock options. But in the meantime, and out of that 250 stock options were vested in me, but 750 are going to vest as per the scheme in the next 3 financial years. Meantime, the company has come with a bonus issue, 1:1. Then what happened is that my stock options are also to be adjusted to the extent of the bonus issue. That means my 1,000 shares will become, suppose 250 I have already exercised my vested stock option, then obviously I will get 250 bonus shares. But against the 750, which are yet to be vested, also the adjustment is to be made. You know. Or accordingly, the price needs to be adjusted. Or accordingly, my optional, that exercise option price need to be adjusted accordingly.
Yeah.
Okay.
In fact, there is a one section, sir. At
So just 1 minute. What I'm driving to the
sir.
point is, in case of stock options are there, if you are coming with any kind of corporate action, that is rights issue or bonus issue, please ensure that how that options which are yet to be vested, how to deal with that. You have to also give sufficient care to be taken about that. Yeah. Yes.
Sir, there is a section 120, I think 6 of the Companies Act. In fact, this section speaks about only the pending transfer of shares. You know, the shares transfer forms were there with the company and the company did not register. And now you are going for a bonus issue or rights issue or dividend, whatever. There they have provided a provision saying that you should reserve clearly those bonus issue, dividend, and also the rights issue portion to the transferee, not to the transferor. So maybe a similar provision we should, sir, as you rightly pointed out, we should extend even to the ESOPs. We should extend to the
just 1 minute, Tripal, what you said, come back again. What you said?
Section 120. Yeah, transferee.
When it is?
Section 126. Yeah. See, there is a physical share transfer, sir. And pending with the company. Now you have gone meantime bonus issue or rights issue.
See, you meant to say what you are trying to say is in case of physical share transfer, the transfer form has been lodged with the company. Am I correct?
Yes, absolutely, sir. This is the
In
section I
that case,
just
you say that the shares are to be given to the transferee. No, that is not a correct answer. What you have to do is, it may so happen the transfer form in physical mode, what you are lodged with the company, there may be some kind of deficiencies in that. So the company cannot register the transfer. So what will happen is, as on the date of the record date or the book closure, whoever is the member as per the register of members, only he will get it. Now, for example, if the somebody has sold the shares, the seller has sold it to the buyer, it is among themselves, and the seller's name is still continuing in the ROM because the
correct,
shares were not effectively transferred to the buyer. In such case, the transferor will get the bonus shares and he is the custodian for the transferee. And
correct,
once that particular transfer takes place, he has to also transfer the bonus shares to the transferee. That is what the law is.
correct. Yeah, this section 126 supports the same. What you are saying, sir, the 126 supports the same. So I'm just trying, this same logic can be extended to the ESOPs entitled holder, NCD, convert CCD entitled holders and CCPS entitled holder. But most of those terms of agreements also will speak about it. So even though law doesn't say that, we should reserve the bonus issue. That is my submission.
And since we are talking about this, let me also bring one more point.
Sir.
Nowadays, if the dividend is not encashed for a period of 7 years, the corresponding shares are also to be transferred to IEPF account.
Yeah.
And when these corporate actions taken, rights issue or bonus issue, in case of bonus issue, the corresponding bonus shares of the original shares transferred to IEPF, these bonus shares are also to be transferred to IEPF account.
Correct.
So as and when the shareholder is going to claim the shares, the IEPF authority will release the shares together with the bonus shares. However, in case of rights issue, that rights you don't need to give it to IEPF authority because there is nobody is going to submit that money. So in case of rights issue, what you will do is, suppose if there are the total capital of the company is, say, for example, 1 lakh shares, out of which 10,000 shares have been transferred to IEPF account, you will come with the rights issue only against 90,000 shares, not on 100,000 shares. Yeah.
Yeah, yes, sir.
Yes, thank you for the insight. Regulation 294 further states that bonus issue shall be made only out of free reserves, securities premium, or capital redemption reserve. Reserves out of revaluation of fixed assets shall not be capitalized for the purpose of bonus issue. Bonus shares shall not be issued in lieu of dividend, and allotment of bonus shares shall only be in dematerialized form. Regulation 294 also details about the treatment for SR equity shares to be given in case of bonus issue. So, bonus issue on SR equity shares shall carry the same ratio of voting rights compared to the ordinary shares. Further, this regulation states that SR equity shares issued in bonus issue shall be converted to equity shares having voting rights, same as ordinary shares, with the existing SR equity shares. Regulation 295 of the ICDR regulations talks about the timeline for completion of bonus issue. So, in case the company announces the bonus issue after board approval and there is no requirement for shareholder approval, in that case, the company shall be required to implement a bonus issue within 15 days from the board approval. And in cases where shareholder approval is required for bonus issue, then the bonus issue shall be implemented within 2 months from the date of the board meeting where the decision to announce the bonus issue was taken. They have also detailed and given an explanation as to when will the bonus issue be considered to be implemented. So it is implemented on the date of commencement of trading in respect of such bonus shares. Regulation 17 of ICDR regulations specifies a lock-in on bonus shares. So, equity shares issued to venture capitalists, AIFs, etc., pursuant to bonus issue, shall be locked in for a time period of 6 months from the date of issue. Coming to the provisions of record date, which is detailed under Regulation 42 of the LODR regulations, the company shall be required to intimate the record date to all stock exchanges in case of bonus issue. The notice of book closure and record date shall go at least 7 working days prior to the record date. This will include the date of intimation as well as the record date. So this intimation has to go to all stock exchanges, and entity shall ensure a gap of at least 30 days between 2 consecutive record dates. Detailing the procedure for issue of bonus shares in case of listed companies. The listed companies shall first obtain an in-principle approval from stock exchanges in respect of such bonus shares under Regulation 28 of the LODR regulations. A prior intimation shall be sent to all stock exchanges of the board meeting at least 2 working days in advance. The calculation of the 2 working days is excluding the date of the meeting and the date of intimation. This is detailed under Regulation 29(1)(f) of the LODR regulations. The company shall also be required to close the trading window as per the PIT regulations to prevent any kind of insider trading. The company shall call a board meeting for considering the resolution for bonus issue under Section 63 and read with Section 179. Upon the conclusion of the board meeting, within 30 minutes of closure of the meeting, an intimation of the result of such resolution shall be sent to the stock exchange. And it shall also be placed on the website of the company within 2 working days. SEBI had issued a circular in which they detailed the disclosure required to be made to the stock exchanges within 30 minutes of the board meeting in case of bonus issue. So what are the details that they seek in such intimation? So the intimation, the company is required to disclose whether the bonus issue is out of free reserves or securities premium, or what is the source of such bonus issue. The bonus ratio, that is in what ratio will the shares be issued. The pre and post capital structure of the company pursuant to such bonus issue. The required free reserves for the implementation of the issues and the free reserves available with the company as on the date of the disclosure being made, and an estimate date by which the bonus shares will be credited to the shareholders. This has to be discreetly stated in the intimation filed with the stock exchanges. Further, pursuant to the board resolution being passed, the company shall be required to file Form MGT 14 within 30 days under Section 117 of Companies Act. The company shall be required to call a general meeting for passing of ordinary resolution wherever applicable. A disclosure for the proceedings of the general meeting shall be filed within 24 hours. And shall be posted on the website of the company within 2 working days. The results of e-voting by the shareholders is required to be submitted to the stock exchange within 2 working days of the conclusion of the meeting under Regulation 44 of the LODR regulations. The company shall fix a record date for identifying the members eligible for the bonus issue. And an intimation of the record date shall be sent to the stock exchanges at least 7 working days prior to the record date, which will be calculated by excluding the date of the intimation and the record date itself. This is under Regulation 42, what we already discussed about. The advertisement of record date shall also be circulated in the newspapers under Section 91 of Companies Act, and shall be placed on the website of the company and filed with the stock exchanges within 24 hours. The company shall be required to call a board meeting for the allotment of shares once the bonus issue is effected. An intimation shall be sent to the stock exchanges depending on the materiality policy and the issue size that may be involved. Companies shall be required to file Form PS3 under Section 39 of Companies Act, and in case of foreign shareholders, Form FCGPR shall also be required to be filed. Further, an application shall be made for listing of such bonus shares with the stock exchanges, corporate action form with the depositories for dematerialization, and finally, the company shall be required to obtain trading approval with the stock exchanges in respect of the bonus shares. Coming to certain case laws related to bonus issue. So certain case laws which help us understand bonus issue more in detail are State of Gujarat versus Dinesh Chandra R. Shah. In this, the question before the court was that can a bonus issue be issued to increase share capital beyond the authorized capital without obtaining shareholder consent for such increase in authorized capital. So the court in this issue ruled that the bonus issue and the approval required for increase in authorized capital cannot be clubbed together. There has to be a separate approval for increase in authorized share capital. And after the same only the company can issue the bonus shares. The next judgment is General Electric Company Limited versus Maharashtra, wherein the issue of bonus shares by a company that has heavy losses was questioned. So in this, the court ruled that the company issuing bonus shares must be only out of genuine profits or reserves of the company. There is no concept of issue of bonus shares out of any accumulated losses. Ramlal versus Mahindra and Mahindra Limited, wherein the question before the court was that can bonus shares be challenged in the court on the basis of procedural issues such as non-disclosure of certain material facts. The court ruled in this that the procedure followed by the company for issuance of bonus shares must be strictly adhered to as per the Companies Act, Articles of Association, and any other applicable provision. If the procedure is violated, the bonus issue shall be the court has the right to set aside the bonus issue in such cases. G. Narayan Swamy versus JK Industries Limited. The question was whether the non-issuance of bonus shares to a shareholder in the company, despite the company declaring bonus issue to other shareholders, can be subject to a legal challenge. The court ruled that shareholders of the company shall be treated equally in case of bonus issue, and any kind of discriminatory practices in issuing bonus shares would violate the basic shareholder rights and can be subject to legal challenge and invalidating the bonus issue. Tata Tea Limited versus Registrar of Companies, whether capitalizing free reserves for issuing bonus shares is legal. This was in the initial stages where the concept of bonus issue was being analyzed. So the court said that capitalization of free reserves for the issuance of bonus shares is a legitimate practice, provided it is done as per the provisions of the Companies Act and the AOA. White versus Bristol Aeroplane Company Limited. Herein, in this judgment, the court had said that members can be given bonus shares of the same class that they already hold or of any other different class as well. Tata Steel Limited versus Union of India, whether the company has the ability to issue bonus shares using the securities premium account. This is also a judgment that dates back to the initial experimental phase of bonus shares, wherein the court said that the securities premium account could be utilized for bonus issue, provided it is consistent with the provisions of the Companies Act. Certain FAQs on bonus issue of shares. The first issue that may come for consideration is, can a circular resolution be passed for the issuance of bonus shares? Can the board approval be by circular resolution? So the answer to this is no, since as per Section 179 of Companies Act 2013 provides that any resolution related to issue of securities shall be passed at the meeting of the board of directors. Second question that frequently comes to the mind is, can preference shares be issued through bonus issue? The answer is yes, because Section 63(1) lays out that company may issue fully paid up bonus shares to its members. Emphasis on the word shares. Shares is specifically defined under Section 284, which means a share in the share capital of the company. Further, Section 43 of the Companies Act recognizes preference shares being a part of the share capital of the company. So, a bonus issue of preference shares is actually allowed by the law, and recently it had also been done by TVS Motors Company Limited, as recent as in the year 2024 itself. Does issue of equity shares by bonus issue require approval of the preference shareholders of the company? In this, it is essential to have attention towards Section 47 of the Companies Act, which talks about voting rights. And it says that the preference shareholders can have voting rights in particular circumstances, which is if the resolution directly affects right attached to preference shares, any resolution related to winding up or repayment or reduction of capital, or all resolutions if the dividend remains unpaid for 2 years or more. So the requirement for obtaining preference shareholders approval for bonus issue will depend on this criteria and specifically to that issue, what is happening as per the bonus issue. Yes. With this, I come to the end of my presentation,
I want to add
and
one
I will now.
FAQ. I want to add just to this one FAQ is that whether
Yes.
issue of bonus shares is it a related party transaction? Okay. So earlier the clarity was not there, but we have taken industry has taken a call that since the bonus shares were issued along with the promoters, directors, KMPs who are the related parties, the shares were issued across the company in the same ratio. So hence it is not a and plus there are certain procedures or compliances are prescribed in the act itself or in the regulations. Since we are complying with all those things, there is no need to pass a separate resolution approving the related party transaction. With the
Jasmine, you
recent
can close the sharing.
with the
Jasmine,
recent
you can
amendment
stop
of
sharing the
listing
PPT. Yeah.
with the recent amendment of listing regulations, that it is exempted. This kind of corporate actions like issue of right shares, issue of bonus shares, the same are exempted from the related party transactions. For the issuing company, it is not a related party transaction and no need to have separate approval for that. Yeah. Yes, Bala, now you can take care of that
Yeah,
questions.
other question.
Yeah. Is it compulsory that the accounts must be actually audited before the issue of the bonus share out of the reserves?
What is that? Come back again.
Is it compulsory that the account must be audited before the issue of the bonus share of the fresh reserve, free reserve?
Otherwise, how we will come to the what are the free reserves? So according to me, that latest audited financial statements are to be taken as the base for arriving the free reserves, out of which only bonus can be issued.
Okay. Key takeaway. Somebody has actually shared the key takeaway. The provision of the bonus share issues in case of the defaults and underscore the importance of fulfilling the finance obligations towards the creditors and employees before rewarding the shareholders. That is what he says actually.
That is not a question.
Yeah, this is a thought he is actually sharing. Section 63 of the Companies Act explicitly prohibits the issuance of the bonus share by a company that is the defaulted in, they given the condition, the payment of the interest of the principal and the payment of the statutory dues and
It's the
etc. and other thing and all
information.
which he
Mr.
has given.
Bala, this is information. You can skip this. Go ahead.
Okay, this is for information. Okay. Many people are actually putting up the question asking for the PPT. We have been telling also in the earlier form also, PPT is actually not being shared, actually recorded webinar is disseminated to all. It will be available in shortly for this. Even the earlier recorded webinars is also available. You can watch it, which actually contain the PPT. Please guide about the fractional share, how to actually create a trustee, etc.
Fractional shares.
In case whenever a company comes with a bonus issue, it may so happen that some fractional shares may be there. Because, for example, if a company is coming with 1:2, I mean 2:1 or whatever it is, fractional shares may happen unless until it is a 1:1 kind of thing. That point of time, in the while approving the board resolution of the bonus shares itself, this issue is also to be addressed, and the necessary powers are to be given to the board of directors to dispose of the shares. Normally, what happens is we create a trust of any two people can be there. That trust will be allotted these shares. That trust will dispose of the shares in the market, and whatever the proceeds are there, in proportion to that fractional shares, that will be distributed among the shareholders.
Does the
Same thing may happen
FCGPR
with the rights issue also. Yeah.
Does the FCGRP is to be filed for the bonus issues as there is not inflow of the money is in the country?
Yeah, FCGPR is to be filed other than the cash flows. There are certain circumstances apart from the bonus issue. If there is a issue resulting in the amalgamation measures, like circumstance, FCGPR provides the options apart from cash flows. When there is a change in the shareholding, you have to file FCGPR.
Yeah, correct.
It's a mandatory.
A private limited company has never declared dividend during the year 23-23. The said company actually issued the bonus share out of the accumulated profit without declaring the dividend. Is it okay? Probably, I think he is asking this question because there is a clause is there that bonus cannot be issued in view of the profit. Probably
Dividend,
that is why he is asking
dividend.
this question. Yeah, that
it
is what
says
I think he is
dividend.
asking. Yeah.
See, it is not mandatory for a company to declare dividend before coming with a bonus issue. So there is no problem.
In fact, one recently we did, sir, we have created the company in July. Then we have got some shares allotted through some premium. Then after that, investor, they want to have the bonus issue also. So we have issued bonus issue by using the existing premium account. That's all. We didn't have the company, in fact, 1 year also not completed. Because
can a company capitalize? Yeah, yes.
The section 63 gives you 3 sources for the conversion, or rather the issuing bonus shares as a fully paid. One source is the pre-reserves. The next one is the security premium account. Third one is the CRR. All 3 are independent sources. If they are available, you can certainly pass a book entry. As Balakrishnan are saying that it is a book entry. You just move from here to there. It is possible, but you have to do proportionately.
Can a company capitalize the funds lying in the surplus retained earnings for the issue of the bonus share? It is very clear because any free reserves which can be actually used, because generally when you say retained earning is actually there in the free reserves only. And apart from that, yes, the share premium account CRR, which has been also discussed. The only prohibition is in case of the revaluation reserve, etc., any reserve which was created for the specific purposes, those things cannot be used actually. I think someone has to help me for the earlier questions, because I changed the network from one network to the other network. Because of that, the earlier question is actually vanished in the chat box. Dipti, I think you could help me actually earlier than this.
I think
I think
our-
before 11:40, most of the question has been actually answered earlier. Also,
answered. Yeah.
I also put up answered, and Tripal is also answered the questions actually.
Yeah,
Yeah.
I think few new questions you can take, sir. New questions.
Yeah,
are
new questions
there
I
now.
already. Yeah.
So,
Yeah.
Yeah.
Right, two more questions had come.
Yeah.
At
Okay.
12:36, 12:35, there's a one question.
Yeah.
36. Yeah, two questions are
Yeah.
there.
Yeah. Let me see. Yeah. Whether there is any limit for the reverse that can be utilized here, if there is any limit. To what, see, the question is like this, what extent the bonus share can be actually issued? That is one thing.
Basically,
And second thing is
entire free reserve can be used for issue of bonus.
Yeah. Whether there is any limit in reserving the things. That's what he is asking.
Yeah, see, we don't have a similar section like 123, where it says clearly that in the event you are declaring dividend, not having profits for the current year, you are drawing from reserves and surplus. There's some set of rules are there, how much you can go, you cannot leave more than 10%, 15% average, all those things. But if you look at the section 63, we don't have any of those conditions. So it says all three heads, if you want to convert fully into the capital permanently, you can certainly do it. Entire previous can be moved into the bonus issue. Then your entire CRR can be moved, because CRR, as presented in the presentation, it can be issued only for bonus issue. The entire CRR can be moved in one go as a bonus issue. There is no problem. Then coming to the third aid also, security premium account again, except those capital reduction, you can't use for any other purpose. That also you can use completely for the bonus issue. There is no issue. Coming to pre-reserves, if you move, then there is a problem. You may be not able to declare the dividend. That is an internal policy of the company. Otherwise, as statutorily, there is no restriction to pay the dividend. It means issue the bonus issue. Size could be any extent. Only provided you should have authorized share capital.
I think we have covered.
Is it mandatory for an unlisted company to issue the public, actually you got this, public announcement? Okay. Should it be amended in giving the dematerialization authorization post amendment of rules 9B?
The question
It is immaterial whether you amend your articles or not, you have to comply with the act.
I think we
Yeah,
covered.
that's all I think.
Yeah, see
I
that
think,
demat
I think
again.
it is 1 minute 6. Since we have some time, then let us discuss also one or two innovative cases of this bonus issue.
Yeah.
One is in case of Reliance Power Limited, where the promoter has declared bonus issue out of his own shareholding. Just to bring to the notice of these people, these kind of innovative, what's called as, instruments, though they were called as bonus issue, but they have been not been brought under the section 63. They have been brought under a separate scheme of arrangement. Whether it is bonus preference shares or Hindustan Liver Limited has come with a bonus debentures in the year 2001, if I am not wrong. So all these have been brought under the scheme of arrangement, which is approved by the erstwhile CLB and present NCLT. So in case of Reliance Power, what happened was that when the shares got listed, there was a major crash in the market. and it has come down that from the issue price, and to compensate the shareholders who have subscribed for the Reliance Power issue, the promoter, out of his holding, he has declared a kind of bonus shares to the subscribers, I mean, to all the shareholders. At that point of time, obviously, when he is coming with the issue of bonus shares out of his own holding, the promoter is not entitled for the bonus issue. That's how the board has approved the scheme. That scheme got approved by the NCLT, then the shareholders have been given. So this is actually just to compensate the losses incurred by the shareholders because of the stock market debacle. On the date of listing itself, this happened. Unfortunately, unfortunately, that company never traded at the issue price. Second case was with case of Hindustan Lever Limited. They came with a bonus debenture. That was the very unique thing in the year, the early 2000s. I think, if I am not wrong, that 2001 they came. That point of time, what they did was they have given the debentures to the shareholders. They're called as bonus debentures, which are redeemable in nature. And if I am also not wrong, they are unsecured debentures. And ultimately, what the shareholders got benefited is those debentures got redeemed after, I think, 5 years or so. I don't remember exactly the terms and all. But if one is interested, they can go. But we are just discussing the concept. So the shareholders got that thing because the company at that point of time was having a great pressure on the liquidity. So that to declare that the dividends and all, though it was not in lieu of dividend, but to reward the shareholders, they came with a kind of bonus issue of debentures. Recently, TVS came as Jaswin has rightly mentioned about bonus issue of preference shares. If I'm not wrong, TVS also came and got I mean, they brought this issue of bonus preference shares by way of scheme of arrangement only. So when, in case of suppose if the companies which are listed on the stock exchanges, they can issue superior right equity shares. That's called as SR equity shares to the promoters. SR equity shares cannot be issued to anybody else other than the promoters. So in case of SR equity shares, what happens is that the voting right will be but they will get additional voting shares, or I mean voting power. Suppose if every shareholder is getting 1:1, one vote, one share, whereas in this case, one share they will get 3 votes, 5 votes as per the issue terms. These SR equity shares also, you may give the bonus shares to the SR equity holders, but these bonus shares also to be converted into normal equity shares together with the original SR shares as per the terms of issue. Same is the case with the preference shares also. Unless until it is clearly mentioned that these preference shares will be redeemed separately as per the scheme of arrangement, these bonus preference shares are also to be redeemed along with the original preference shares. So these are some unique way of issuing bonus shares. Yeah.
There was also one question that whether promoter can reject the bonus shares, means he is not accept bonuses.
You're talking about waiver. Actually, it is a waiver of bonus shares. See,
Waiver of
this
bonus.
question, yeah, this question is there even for the dividend also. Can a promoter waive his right for dividend in case of, if you say that in case of Reliance Industries, that in the subsidiaries, this thing that, sorry, all the subsidiary companies which are holding the shares of RIL, again, normally a subsidiary company cannot hold the shares of a holding company, but this particular, there are some subsidiaries, if you know the RIL shareholding, these shares have come by way of a separate scheme of arrangement where the subsidiary companies that they are holding by way of a trust or something like that is there. That's called as treasury shares. So there they used to waive the dividend. Whether they, but in the case of Reliance, what used to happen was, and then we have of course sought legal opinion and all those things. What it was said is before the board declare the dividend or recommend the dividend to the shareholders, the waiver request has to reach the company. Because once you recommend or declare the interim dividend, then you cannot waive subsequent to that, because once it is declared, it becomes a debt. It is to be paid to the shareholders.
Right.
So this is not as very simple that you cannot say yes or no in a webinar like this. Technically, yes, there is no prohibition as such. A waiver is possible by the promoter to the bonus shares. In case of Reliance Power, it has happened. But while you are going to take this kind of a decision, please see the implications, legal implications under the Act, under the regulations, under the tax implications. And also, you have to better to have a support of a legal opinion from what's called as an expert in that particular line before you act upon. Yeah.
Okay.
Yes, Sudhakar, when you talked about this Hindustan Lever case, I think around the same time, I was referring the case where, we refunded the cash to the shareholders. Because around that time only it has actually happened. In our board, we have some eminent people. So that time when it was actually discussed, they referred this particular case in our board. He said, why not we also do that? That is what they are telling. But again, as I said very correctly, the question came the liquidity. Company had got enough surplus cash actually. That was the king. The whole point of refunding the money comes when you have the liquidity. So they have the enough cash-rich company. So, and again, the question came, we don't see the color of the money. So that was it is matter. We also got for the compromise and arrangement, and then we got the High Court approval. Even the Hindustan Lever that time, as you rightly say, they also got the High Court approval after getting the approval from the shareholders.
Yeah, I think all the
NIPC also issued the, there are two more things there. NIPC also issued the bonus share. It's information. Somebody is actually make a complaint. I have not received the bonus share from the Reliance. I lost the money. I will not be able to answer any question. None of us can answer this question actually. We don't know what is the reality and other thing. Remember the case of the Silverline Technology, but the company defaulters, NPA company is almost sales of the profits for many years. Allot the share at the preferential spells out the investors, etc. Now actually traded in the items of the shares allotted price yet almost
again information.
Yeah, again for the information. Yeah.
If honest,
I think we are yeah.
Is the form. Leave it. I think we have answered all the questions. We can close this.
Yeah.
Any panelist has to comment or anything additional, or we'll close? Tirupal.
Let me tell you one thing. I would like to definitely appreciate the very good presentation which is made by Jasmine. She actually brought out the very finer points. Although the issue of the bonus is a very small topic, but it has got its own intricacies and various compliances, procedural issues. And especially we are very thankful to Tripal and as well as Sudhakar sharing their practical experiences in many issues like article of associations and memorandum, and then again forfeiture of the tax, again uncalled share, etc. and other thing, and all those things. Again, one more very valid point is whenever the table A, which is to be adopted and other thing and all where it is there, all those things are all very practical relevance. Again, it goes back. We have to do our homework. That is where we are again coming back. As a company secretary, unless we are thorough in our homework, things will not go that smoothly. That is the point we are again coming back. Yeah.
Yeah.
To you, Dipti.
Yeah, thanks everyone. Thanks Tirupal for your inputs.
Thank you, madam.
Thanks Sudhakar. Whatever different aspects you brought to different points in the presentation. Thanks a lot. Thanks Jasmine for detailed presentation. Thanks everyone for your participation. Thanks a lot.
Thank you to all. Good day to all.
Thank you.
Thank you to all. Have a good day. Have a good weekend.
And happy independence.
Bye. Thank you.